Joining me now is Randy I, employment lawyer. He joins us from Moncton tonight. Thanks for your time.
No problem. Thank you for inviting me.
Can employers do that, give an employee an ultimatum like this and threaten to essentially, I would say, fire them?
Well, I think we need to look at this from two different angles. One, which is the systemic statement to all of the employees that you have to work harder or resign or leave the organization, as opposed to a specific direction to one individual employee. So if we are looking at this systemic statement to all of the employees, this is, I would consider, a policy of corporate Darwinism, right? The organization is trying to eliminate certain members of staff in order to have a leaner organization, perhaps an organization that fulfills Mr. Musk's vision of what Twitter would become or should become. But if this directive was given to a particular person, I would argue that under Canadian common law, this would be constructive dismissal. This is essentially tantamount to the termination of that employee as they're being essentially kicked out of the organization, and they would be entitled to sue.
Okay, have you ever heard of something similar in this country where a boss said in a wide-reaching kind of way, do this or you're out?
I mean, this is fairly unprecedented. Right? Elon Musk is Elon Musk. He does things in a particular flashy way. He is the world's richest man, and he has a particular idiosyncratic way of communicating. I've seen cases in my practice where this type of direction was given individually to an employee, where the boss may say, you need to work 80 hours a day or you're out. And at that point, I usually got a phone call from this employee saying, that's unfair, that's abusive, what can you do for me? And as stated earlier, there could be a cause of action for constructive dismissal at that point because the fundamental terms of the employment relationship have been repudiated.
Give me an idea of what you mean by fundamental terms, because we all have conversations with our bosses at some point where they say, hey, we want you to take on a little bit more responsibility, or we're going to sort of change the focus or pivot you to this kind of work. Where does the difference lie between what is an okay amount of work or change your direction to what is not okay?
Suppose you're hired and traditionally you work 40 hours a week, and suddenly, without your consent, a unilateral directive is given by someone superior to you, someone upstairs, saying now you have to work 80 hours, double the amount of time. Something that is completely unreasonable and completely not parallel to what traditionally you have been doing. That, I would argue, would constitute constructive dismissal.
Okay, but that's a doubling of time, so that's significant.
And even if it's not the doubling of time, suppose you work 40 hours and now you're required to work 60 hours, 70 hours, something that is significant, right? Not something that is just a marginal increase. If it's a marginal increase, I don't think the courts would conclude it is constructive dismissal. But if it's significant and it changes the nature of your responsibilities, changes the nature of your duties, changes the nature of how you work for the organization, then I would argue you would have a cause of action to sue the organization.
So, Randy, it sounds like Elon Musk is going to be sued by a number of employees.
I believe so, and I think he's already being sued by a number of employees, including a class action in California under California law for not providing enough notice to their employees there in that particular state.
Yeah, he really does like to do things on the fly. Randy, I appreciate you joining us tonight. Thanks very much for sharing your time.
No problem. Thank you for inviting me.